Good evening, everyone. For now, I'm just going to give the introductions and welcome to everyone. I think this is going to be a really good presentation. So to start out with, let me introduce to everyone Joseph Accetta. Joe is a court attorney referee in the adult guardianship part of Supreme Court of Westchester County, White Plains. Prior to that, for about 20 years, he was in the surrogate's court in Westchester County, first as the principal law clerk to the surrogate, and then as the chief clerk. That was until 2015. He has taught legal research and writing, appellate advocacy, and surrogate's court practice as an adjunct professor at Pace University, Elizabeth Allen School of Law, Berkeley College, Mercy College, and Westchester Community College, and he's a frequent lecturer on surrogate's court and guardianship, elder law matters for the New York State Bar Association, the Westchester County Bar Association, and many other bars and civic organizations. So let's welcome Mr. Accetta.
Thanks, Dan. Good evening, everybody. Dan asked me to speak to this group. I do lecture frequently to custom estates groups and guardianship, adult guardianship groups, mental hygiene, adult guardianship groups. This is a little bit unusual. So what I thought I'd do was piece together some common proceedings and some common statutes that you might want to be familiar with in terms of real property, co-ops, and how those entities are disposed of in the courts and what some of the reasoning is behind some of those. I'll start out with the surrogate's court because I spent most of the time there. And when you're talking about real property, of course, all of you know co-op shares are what you sell. You don't sell physical co-op when you're dealing with a co-op. So technically it's personal property, but a lot of the same principles apply. You're dealing with Article 19 of the Surrogate's Court Procedure Act, okay, where applications have to be made for certain dispositions by, in the case of the Surrogate's Court, the estate fiduciary, the executor or the administrator. Notably, for those of you who know a bit about fiduciaries and appointments of fiduciaries, they're trustees and guardians in the Surrogate's Court as well. Those two fiduciaries are not involved in the disposition of real property or co-ops and condos, at least within the context of the Surrogate's Court. For guardians, that changes in the mental hygiene part.
Yeah. What's the Surrogate's Court?
What's the Surrogate's Court? Okay. The Surrogate's Court is the court where people's estates, primarily, if you, for instance, we're in Westchester County, if you die, what's called a domiciliary, where your primary place of being where you intend to return to is, if you die in Westchester County, your estate can be administered or should be administered through the Westchester County Surrogate's Court. There are 62 counties in the state. Your county of domicile, if you are a New York resident, residency and domicile are not interchangeable. One can have many residences, but only one domicile. That's the place where you intend to return, or when you die, all of the facts that come into the court, your court records, your tax records, your licenses, that's the court ultimately that administers the estate. The Surrogate's Court also has jurisdiction over trusts, testamentary trusts, which are trusts and wills, vivos trusts, or lifetime trusts, and guardianships, and most counties adoptions. Okay, so that's the Surrogate's Court. Okay, there's a surrogate judge. He presides over all these estate matters. Hopefully that answers your question. Okay. Shouldn't have made that assumption. I apologize. Okay. And the Surrogate's Court has its own procedure. Are you familiar with the civil practice law rules for general practitioners? Are you a lawyer?
No.
You're not. Okay. So each court pretty much has its own procedural rules. The SCPA, or the Surrogate's Court Procedure Act, are the procedural rules that govern the Surrogate's Court. Okay, you have to follow those procedures if you're going to bring an application before the surrogate. And the application I'm talking about typically involves the disposition of real property, whether it's a sale or a mortgage or lease or something along those lines. Okay, this is Article 19 of the SCPA that we're talking about. Again, dispositions are typically sales and mortgages and leases. The fiduciaries are typically executors where there is a will, administrators where there is no will. And the purposes are fully set forth in SCPA 1902, and I'll just read to you from the statute. And this is usually an application by a fiduciary to sell the decedent's real property to pay one of the following categories. Let's see. Pay administration expenses of the estate. Okay? You attorneys out there, that's your fees. Okay? For you fiduciaries out there, that's your commissions. Okay, those are the typical administration expenses. If there isn't enough liquidity in the estate to satisfy those expenses, you have to read Article 19 hand in hand with SCPA Article 18, specifically 1811, which is sort of the priority for the payment of administration expenses and debts by a fiduciary. So you have to read this hand in hand, and if you realize that you don't have enough liquidity to satisfy all of the obligations, it may very well be that you need to come to the court under Article 19 and make an application to sell real property. And that's just the fact of life. To pay the administration expenses of these things, pay funeral expenses. Okay? Many people typically now have prepaid funeral trusts of some sort. If that's not the case, the funeral, I can tell you right now, from my years in the surrogate's court, we used to keep on the front counter what we used to call the book, where creditors would check every day to see new estates that were coming in. Funeral homes were always the primary visitors to that book. They usually first paid because they're usually doing the first thing that an estate entails. They're helping to respectfully dispose of somebody's remains. So paying funeral expenses. To pay the decedent's debts, judgments, or liens, except for mortgage liens, and you can't use the surrogate's court to help satisfy your mortgage. Okay, that's another entity entirely. We're not going to get into foreclosures too much at this point. Okay, or proceedings on notes and mortgages in the Supreme Court, of course. To pay state taxes, to pay legacies. Okay, again, if a will sets forth that certain people are getting X amount of dollars, and the estate has that value, but most of the value is tied up in real property, it could very well be that the executive or administrator could make an application to the court to liquidate the real property, to pay those expenses, to pay those legacies. To pay residuary or intestate shares, again, that's where there's no will. Residuary, of course, is the catch-all phrase in the will which says, and I give everything else to so-and-so and so-and-so. Okay. And for any other purpose the court deems necessary. It's the language right out of 1902. So the process is by what's called a petition. In the surrogate's court, they don't have summonses and complaints. You have a petition and a citation. And the citation is the notice to the interested parties in the estate, including any creditors. Okay, they're entitled to be brought into the proceeding to have their say in terms of what the nature and the extent of their obligation is, and why. Again, if it's a person who is is coming into inheriting the real property, and they're being told in a petition, well, we need to sell this real property because we can't satisfy all the obligations, they have a right to come to court and explain why that shouldn't be. Okay. And hopefully they have a good set of facts behind it. If the court is usually in a position where it wants to honor the obligations of the estate, and unfortunately, it sometimes comes down to the liquidation of real property in order to do that. So the surrogate's court is a forum for that. You should know that there are no partition actions in the surrogate's court. You have multiple owners as tenants in common and they don't get along and they want to disengage themselves from the tenancy in common. You cannot do that in the guise of a person's estate in the surrogate's court. What your procedure is to come to the surrogate's court, seek permission from the surrogate's court by petition and citation on notice to everybody involved, and seek permission from the surrogate's court for the surrogate's court judge to send it to Supreme Court to then proceed with the partition action under the RPA PL provisions. The real property actions, laws, and so forth. So you cannot maintain an action for partition in the surrogate's court. And you have to, if you are a fiduciary and the decedent was, and you want to disengage the decedent from other tenants in common, you would proceed first by asking the surrogate's court permission, and then assuming the surrogate court grants the permission, you then go to Supreme Court and start your partition action there. Okay? Landlord-tenant proceeding, something I'm sure near and dear to all of your hearts. There's a famous case, which is now close to 40 years old. Okay, for years before this case, 1982, I'll give you the name of the citation if you want to jot it down in a second. The surrogate's court stayed far away from landlord-tenant disputes under the guise of the surrogate's court is a court of limited jurisdiction, constitutionally within New York, or the New York State Constitution, as opposed to the Supreme Court, where you can bring any type of civil proceeding. And the surrogate's court stayed away from these matters, indicating this is really a landlord-tenant dispute. It's a matter between live parties. The decedent's estate is not involved or affected by a landlord-tenant matter. Well, Judge Radigan, who now he's been off the Nassau County Surrogate's Court bench for the better part of 20 years. I think he retired in 2000. He authored a decision that went all the way to the Court of Appeals. The Court of Appeals citation is 57 New York 2nd 278. And the name of the case is matter of Piccione, P-I-C-C-I-O-N-E. Piccione in my house. Okay? Where I grew up. So, Judge Radigan looked at a landlord-tenant matter. It was basically a holdover, was preventing the estate administration from going forward because there's certainly enough liquidity to satisfy all the obligations, but there was a holdover in the real property that was preventing the appropriate transfer of the real property to the rightful beneficiaries. Judge Radigan, in his radical decision at the time, indicated that this really is affecting the administration of this estate, and that's sort of the test under Article 2 of the SCPA in terms of its subject matter jurisdiction. If a matter affects the administration of the estate, it's conceivable that a proceeding can be brought in the surrogate's court. And Judge Radigan sort of gave his blessing to the landlord-tenant matter being in the surrogate's court, went all the way to the Court of Appeals, and the Court of Appeals ultimately agreed with it. Kind of was a tennis match, went back and forth. The appellate division reversed, and I think Piccione restored it. So it's a very interesting concept that may, depending on the way you practice, if you're a lawyer, and depending on where you are, if you are involved in real property, the surrogate's courts differ greatly on how this matter, Piccione, gets applied. I can tell you in Westchester, I worked under two surrogates. The last 14 years, I worked in the surrogate's court. I worked for your current district attorney. And he was very conservative when it came to this, because his belief was, and I think most of the laws and the procedural provisions of the various local and municipal courts, village, town, city courts, that these disputes belong there by statute. Mr. Finger, they can tell you their firm does a significant amount of work in those courts. And every day you see those dockets are full with landlord-tenant matters. Why should the surrogate's court get involved in that? We're looking to administer estates, not get involved in landlord-tenant disputes. But some courts were welcoming to this. Nassau, again, I can pick and choose. In New York City, they pretty much sent you to the local administrative judge that handled landlord-tenant matters. But depending on where you were in the state, some surrogate's courts were receptive to this. Westchester was not. So there's no statute which allows you to have a landlord-tenant matter adjudicated in the surrogate's court, but Piccione gives that authority. It opened up and expanded the subject matter jurisdiction of the surrogate's court to include this type of dispute. So you need to know, the county that you're in. You need to know what the procedures and the proclivity of the surrogate sitting in that county is if you're going to go to the surrogate's court. In terms of economy and efficiency, it makes for one-stop shopping. Because, again, you're looking to sort of resolve a landlord-tenant matter in order to get the estate going and get the administration of the estate moving. That's the argument most people make. And sometimes it falls on deaf ears and sometimes it doesn't. Again, it depends on where you are. So beware of that. The last component of surrogate's practice that I wanted to talk about a bit deals with guardianship, oddly enough. And it'll make for a nice transition to the mental hygiene provisions and procedures I'm going to talk about shortly. Article 17 and 17A of the Surrogate Court Procedure Act deal with guardianships for infants under Article 17, and under Article 17A, guardianships for intellectually disabled or developmentally disabled persons. Okay, those are terms of art. And if you're interested, you can certainly Google the statutes, and those are typically issues, autism, issues involving traumatic brain injury, birth-related injuries, and so forth, when you're dealing with those types of injuries. So autism, intellectually disabled people, the autism spectrum has expanded significantly in the last 10 years, so a lot more people are being included on people who are intellectually disabled, or at least considered intellectually disabled. The point I'm trying to make is under SCPA 1715, which applies equally to infants and to the disabled people I was mentioning, intellectually and developmentally, when you have an infant or an intellectually or developmentally disabled person owning real property, and you want to sell that real property, or lease, or exchange, or refinance, you have to make an application to the surrogate court to get permission to do that. Okay, first of all, assuming that a guardian is in place, the surrogate wants to ensure that the guardian is garnering and securing the funds that are coming in from the purchase. Okay? So we also, on the flip side, if it's a purchase of property on behalf of an infant or a developmentally or intellectually disabled person, the surrogate wants to ensure that the purchase isn't just to make the family feel comfortable with the use of the incapacitated person's money. It wants to make sure that the purchase, first of all, is going to be properly titled in terms of titling the appropriate percentage of the funds contributed by the infant or the ward as a percentage of the deed. But also, especially in the case of the developmentally or intellectually disabled person, the surrogate is not going to permit the purchase of the property for usually a family unit, unless there's a plan for renovation to accommodate physical disabilities if needed. Okay, there's a plan in terms of what you're searching for in the school district that you're seeking to purchase the property in order that the school district, if you're talking about a younger intellectually or developmentally disabled person as well as an infant, that the school district is going to meet that person's needs. And those are some of the types of issues that go into the purchase. Not just because it's a nice family, you know what, let's let them move in, they'll build a swimming pool under the guise of it's used for rehabilitative purposes, and then you have block parties and pool parties all summer for the whole neighborhood. And that's something that the surrogate guards against. It's not appropriate, it's not proper to use the infant's funds for that purpose. Okay, the primary purpose of the purchase or the sale ultimately has to inure to the benefit of the infant or the disabled person. So that's the type of proceeding you ordinarily see in the surrogate's court when you're dealing with people under this type of disability. Okay, an infant or one of the disabled persons I mentioned. You always have to get court permission when you're dealing with the exchange or refinance of real property. You need to be aware of that. Okay, I'll take questions later. I just wanted to segue and spend a few minutes on what I'm currently doing for the last 4 years. I'm in the mental hygiene Article 81 part. Those are adult guardianships typically. Okay, guardianships for the most part for people who are aging. They're starting to suffer from dementia, Alzheimer's, and those types of debilitating issues where the person is no longer able to perform what we like to call ADLs, or activities of daily living. And they're slowing down in life. If a guardian is appointed, okay, usually the person has lived in the community, meaning they've lived in their own home. Now they're slowing down to the extent that maybe they need to be placed in an assisted living facility or even a full-fledged nursing home. And if that's the case, and a guardian is appointed, and the real property still remains an asset of the guardianship, there will usually come a point as the aging process continues and as the years sort of mount up in the term of the guardianship, where it's clear that the incapacitated person is no longer going to be able to go home. they're no longer going to be able to return to the community because their needs have devolved into such where at one point they were having difficulty with their ADLs, now they're incapable of performing any of them without significant assistance. And if that's the case, well, again, unless you're under a certain threshold in terms of your finances, well, living in an assisted living facility or nursing home ain't free, and it ain't cheap, okay? So your assets quickly are diminishing, sometimes at alarming rates, okay? And ultimately, when you have real property and you're down to the point where the guardian is no longer able to make the payments to the home or to the care facility is always lurking. The county is always lurking as sort of a monitor of appropriate government assistance if Medicaid is appropriate and an application hasn't been granted. Okay, but we're always monitoring that threshold. And if there comes a time when it's clear that the incapacitated person is not going to be able to return home, the guardian usually comes to the court and makes an application for permission to sell the property. This is not something that the guardian is empowered to do without prior court approval. And just some of the nuances so that you know in terms of what you have to submit. The guardian has to proceed by order to show cause and petition, and accompanying the petition should be several important documents. One is a fairly recent appraisal of the property. A second document is hopefully a signed contract with a third party, and those are exhibits of the petition. And on the return date, the guardian comes in and basically makes the case to the judge, and the judge will typically inquire about the guardian's current physical and mental condition, how have they progressed or regressed in terms of their abilities to conduct their ADLs. Is there a possibility they could ultimately return home even with the assistance of 24/7 aides? And those are the types of questions that you need to be prepared to address if you're the guardian and you're looking to undertake the sale of the incapacitated person's real property. And again, more often than not, the criteria often comes down to the Supreme Court judge's, the guardianship judge's assessment of the person's ability to ever return home in a meaningful way, and also whether the price of the contract hopefully exceeds or is roughly the same as the appraisal price. Anything below the appraisal price, the questions are a little bit more pointed in terms of why is this? Are there extenuating circumstances? Is this an all-cash deal? Is it a matter of, the addict is riding away? There has to be a change from oil to heating because of significant issues with respect to the oil burner. Those are the types of HVAC issues. Those are the types of questions that the judge will ask on the return date, and they'll expect answers from the guardian. And if the answers are unsatisfactory, the Supreme Court judge is not going to approve the sale. It's very simple. Okay? So, remember, the more the assets diminish, and you get below the Medicaid threshold, which is roughly $15,000, now you're eligible for Medicaid. But we have judges that I work for in the guardianship part that are mindful of the fact that somebody who has the wherewithal to continue to pay for their own upkeep and their own lifestyle should not have to go on Medicaid and should not have to become, in essence, a ward of the state. So those are some of the issues that you need to deal with. Foreclosures, I really don't want to spend a lot of time on because very rarely does the foreclosure part cross over into the adult guardianship part. When the foreclosure proceeding does cross into the adult guardianship part is when there's a foreclosure against somebody who perhaps was not incapacitated at the time the foreclosure action was commenced and now has become incapacitated and a guardian has been appointed. The guardianship part needs to be apprised of the foreclosure. And ultimately, if the foreclosure proceeding is going to be resolved, the resolution in the foreclosure part has to come before the guardianship part. And the guardianship judge has to approve of any resolution of the foreclosure. We just had this recently where the person was borderline incapacitated at the time the foreclosure action was commenced. And a year and a half or close to 2 years had passed, where of course interest and penalties had begun to be racked up on the debt. And in a conference, the attorneys in the foreclosure matter were invited to the proceeding because, again, the guardianship judge needs to approve of the foreclosure, and they had reached a resolution in the foreclosure. And the judge leaned hard on the attorneys in the foreclosure action, and then leaned hard on the guardian to see what they could do to negotiate some of those interest and penalties down. Under the guise of, the bank should have been pretty mindful at the time of the foreclosure proceedings commencement that this person was on the verge of having a guardian appointed for them. So, I work for Judge DeBella and Judge Malone are the two adult guardianship judges in Westchester County. Judge DeBella is also the enforcement and compliance judge for all the accountings in 5 counties in our district. That's over 1,800 cases. Okay, I see a lot of them. I see and have to process a lot of the accountings myself. These issues that come up, again, if you're dealing with real property, and you know that Westchester had a significant number of foreclosures, certainly not as high as Suffolk or some of the other counties that are at the top of the list. And Judge DiFiore's, her initiatives have led to the assignment of a lot more referees to these foreclosure proceedings, where now we're getting the numbers down significantly in this county. But those are things you need to be aware of, okay? If you have somebody who's under, and who's incapacitated, or who's been judicially declared to be incapacitated, know that in terms of a foreclosure proceeding, you're gonna have to partner with the guardianship part at some point. Okay. So those are my comments, and again, it's kind of a broad stroke through my experience in the 2 courts that I've spent time in. I'll be happy to answer any questions on this after we hear from our other speaker. Thank you very much for your attention.
Thank you very much. So now next, I'd like to introduce somebody who I think many of us are probably familiar with. I myself am very familiar. But I don't know if I've ever had the privilege of introducing him before. Probably not in any event.
Except for your wife.
So, right.
Your wife? I said except for his wife.
Yeah. So now my mother, Dorothy Finger, who is also my business partner, will speak on the trust.
Good evening, everybody. So, thank you, Joe, for 101 surrogates. And after hearing him, you'll know why I don't do that. Okay? It is a difficult field to practice in, and for a lot of reasons. And if you go to that part, which occasionally I have to do on ancillary matters because of co-ops, and I sit there and I again know why I don't do it. It's very, very time-consuming and very technical. So it is one of the reasons, though, that I am talking to you, because now one of the things that you probably know, or you might know, is that trusts don't go before the surrogate. It's a separate document, and anything that it provides for funds or whatever, the disposition of property in whatever form of that trust, that's it. You don't have to go to it unless there's some kind of dispute. That's a whole other thing. But in the norm, the trust speaks for itself, and the executives of the trust follow, presumably, and their duties are outlined in the trust. And again, I would tell you that although I've been involved in doing a lot of things with trusts nowadays, I would never undertake to write a trust. I really know nothing about trusts and estates. But when I read them, what I do know, or can know, is how they affect a co-op. What those provisions, or condos are not part of this because condos don't approve people and all of those things. But in co-ops, what is in a trust can have a tremendous impact on the rights of the board and the co-op. So trusts avoid probate, and so they're pretty self-contained and automatic, and that means that if they say something, that's it. I've been working at this now for probably about 15, 16 years. It didn't used to come up in co-ops. People were not into trust. It started coming up, and basically one of the things I think that Joe alluded to is the idea of medicating. People wanting, that was the thrust. If you put all your assets into a trust, and there are certain provisions, you are divested of assets, and if that's for a period of years, that if you have to go into a nursing home, your assets are protected, and Medicaid pays for it. That, I think, was a part of a driving force. So it's a way to divest. It also, many of them contain what we call spendthrift provisions, which have to do with protecting the trust against claims of others, including a co-op that might be owed money, or there might be damage, and they would want to recoup that from the person in the apartment, or what was the owner but is now the grantor of the trust, gave it away. So what do? What did I? First of all, I did a lot of research, and I read about what the experts said to do, and I tried to understand it. So when I get a trust in, there are really two types. There are revocable trusts and irrevocable trusts, and those become fairly technical, and it doesn't matter to me as far as protecting a co-op. I don't care if it's revocable or not revocable, as long as it has other things in it that protect the co-op. I want to ensure that the co-op is not at any greater financial risk with a trust than if there wasn't a trust. That's my job. So I say that when it comes, the first thing I do when I get calls from shareholders, and I get calls from the shareholders' lawyer who's going to write the trust, and they say, oh, we're just, we're going to put this in a trust, and we're going to send it in, and what do we do to transfer? Right away they want to know. They say, we don't have to do an application because the person is there. I say, yeah, you don't have to do an application. That's true. He said, well, when can we set a closing? I'll give you the name of the trust. And I say, slow down. Stop. Don't pass go. You're going to talk to me, and you're going to pay me, and you're going to send it to me. You're going to send me your draft version, and then we're going to talk. And what are we going to talk about? So one of the things we're going to talk about is how we are going to deal with the specific language that's in many of these trusts that can have an impact on a co-op. So one of the things is that these, what they call spendthrift trusts, where creditors can't get at it. So I have to put in language that says, except that the co-op can. That this paragraph's just not going to apply to my co-op. It's not happening. So that's one type of thing that is a requirement. Sometimes they don't like that. Sometimes they say, okay, but can we do this? They can be in a negotiation. But my primary concern is, you're not shutting my client out from whatever's there. That's a must. So that's the bottom line. The question is also, who's going to live there, right? So, person's been living there. We're very happy with this shareholder. Never had a problem. Everything's wonderful. And we want to help this person because they're our shareholder. But who's going to live there? Because now it's in a trust. So, I have to make sure that that person is going to live there, and only that person. Or we say a caretaker or family member with the shareholder. Not their children, not their grandchildren, not their nieces. It's amazing how many people want to take care of a lot of other people, and it's very nice of them, and I don't have a problem with it. I just don't want them moving into a co-op that I represent in the guise of, okay, well, now they're going to take care of them, and then they're going to stay there forever. Even if they say, well, you know, it's being left to them in the trust. If something happens to this person, yes, they have a right to the asset, but they don't have a right, without board approval, to have the shares transferred to them or to live there. So that becomes another item to be negotiated and talked about and figured out. And what happens if they go into a facility, and are they coming back or they're not coming back? So that's language that we have to massage, and we have to make sure that the co-op is protected. What else? The issue of honoring all of the rules and regulations on the proprietary lease. I want to make sure that that's in there. I also insist on a guarantee of the, of the payments of what is into the co-op, whether it be an assessment or whether it's the maintenance. So that has to be in there. So not only does the shareholder, who is the grantor now, guarantee it, because then they have other assets that are not in the trust too. Sometimes it's a combination of how they operate. So I want the shareholder and I want the trustees to guarantee their obligations. One of the sort of just a legal issue, and doesn't seem like much, is the location. Suppose you have a dispute with the co-op, because even if they're living there, there could be a dispute over maintenance, there could be a dispute over behavior. You know, we all know that in co-ops, we can sometimes have a problem with the shareholder. And many times they put language for various reasons into the trust as to where a lawsuit can be brought, and whether the trust, what they call the locale, can be someplace else. And I like Westchester. I'm a Westchester girl. I like the green. I like White Plains. I like the Supreme Court in White Plains because I know people. I like the surrogates and the guardianship because I know Joe and I know, I'm comfortable here. And I'm comfortable in the local courts. I may not like all the judges, but I'm comfortable there. I know what to expect. So I have to make sure that the site that's in their language for the trust, that the trust assets have to be here, that the location for the venue for any action is Westchester County, in any of the courts in Westchester County, and that the law of New York State will apply. And that's kind of a bottom line. I usually don't get too much pushback on that, but I just have to be aware every time I look at it that that's in there. So that's something that sounds simple, but it's one of the kinds of things. I think I touched on most of the items. I insist we put all this, in addition to changes in the trust that I insist on, I have a form of an agreement that says oath, sort of redundant, but it gives a little strength to it. I have an agreement that everybody signs, the shareholder, that's the grantor, and the executors, or trustees, not executors, trustees, and also the guarantee. And when they get all that done, and everybody is signed off and sealed and delivered, then we can talk about transferring the shares. So that's my sum and substance.
Sure. Ready for questions? Sorry?
Sure.
So when the trustee, the grantor signs the trust,
Yeah.
what would a guarantee?
Over that? Oh, it's a guarantee of payments.
Right, but is the trust already doing that with signature?
No, the trust says they're supposed to do it out of the trust. A guarantee makes them individually liable. So, you know, a lot of times I will see, a trust come in and it says, my nephew, John Smith, is to be the trustee and the co-trustee is my other niece, so-and-so and so-and-so, or my son. They're going to be responsible to pay, but they're only responsible to pay from the trust assets. So I say, okay, that's fine, but I'm not sure what the trust assets are going to be. And I'm not sure that there won't be other issues. So I'm going to make sure that, because now we're kind of assuming that the grantor, you know, we don't know what the story is.
It's personal.
Yeah, it's a personal, right.
So you have to see the trust before it's final?
Yes, although there are attorneys who say that it could be amended, and they can amend it to meet what I need, that's okay. Oh, there's another document that reminded me, not for the person doing the trust, but for the lawyer. I get an opinion letter from a lawyer, like the banks do when do mortgages for co-ops. They give an opinion about everything being, you know, perfect. And so I get an opinion letter about the validity of the trust and so forth, so that I and the co-op are protected.
So, Dorothy, quickly, how much do you have to assure that the trust can pay what needs to be paid to the co-op? Do you have to look at all the
I don't-
assets,
no.
the income and all that?
No, we don't do that.
So how do you do that?
Well, we don't do that, but somebody is, look, financially, eventually, you know, just like if there was no trust, you can foreclose, there are other avenues. So the idea, though, is to try to get people to be as responsible as they can be, and to understand if they're going to be a trustee, that they have some serious responsibilities with regard to this property. That's what the purpose is. I haven't had a situation where, you know, where they stop paying anymore. There was a problem, but we want to make sure that it's taken care of in advance. Yes.
Yeah, one of the issues that we're having on board, and I also have an attorney, so a lot of this is.
I know,
Step back. But one of the issues that we're having, and is a concern, is that there are a lot more requests now because it's what people are starting to do for their estate planning. And we're, just as we have issues with estates and executors deciding this, they're just going to sell for whatever, and our values, you know, kind of go down. We've had a big issue with some of the trusts and the trustees saying basically, yeah, well, we don't care, we're just going to sell or whatever. So my question really is, are we obligated as a board to accept these trusts?
No, I don't think you are. But I don't think you're obligated, but I also think that they can't just sell for whatever. I mean, I think the board can look at these things and see why, you know, why is this, you know, if prices are at a certain level generally in the co-op, and this one, you know, that's a financial decision that I think the board.
It is and it isn't. I mean, the board, I don't want to monopolize it, the board, because I was not happy with what the trustee was planning to sell the property for. I said, yeah, no, this is not happening. So the board, under right of first refusal, said, no, we are saying, you know, we're going to offer you this. And they did come up in price. Still not what I want.
Yeah, you have a right of first refusal, which is unusual.
Well, we actually talked to them after, but it's that. But the fact is, my concern is there's so many of these, and I think it's to the detriment of our co-op, and I suspect other people may feel the same way.
I haven't experienced it, so I don't know. We have not, you know, I've had a number, quite a few trusts, but we have not had that situation.
The key is with anything in a co-op is just to make sure you set a policy and that you don't discriminate. So whatever, so if you're gonna decide to accept them, you accept them. If you're gonna decide that you're not gonna accept them, then, you know, and you can then still review each one individually, but, You should have a general policy
We're
too.
moving toward, that's one reason I'm here
This
tonight.
gentleman has.
Doesn't the board have to approve a trust, a title held in a trust? So
Yes,
that-
but,
that's your safety.
well, they have to approve it, but in general, I speak to the board and I say, do you want to allow trusts? As a general proposition, right? And if they say, I say, I can review these things and I can insist on certain things, but as a policy matter. And if they say, well, it's okay, but then you have to do the documents and so forth. But most places are saying it because people want it.
Yes.
And they're trying to accommodate their shareholders.
I am a board member and I have, my apartment is in a trust and it had to be reviewed by the attorney of the property management who changed some of the language.
Right.
So, I mean, that should cover it, yeah. But I have another question, I'm sorry. If the grantor dies, and there's my phone ringing, sorry. If the grantor passes away and one of the trustees wants to occupy the apartment,
I say no. I say they have to
Let's
go
decide
over
to
the
go.
board. Well, that's the language that I put in my agreement. That's the whole,
Well,
you hit the nail on the
But
head.
what stops them is they're not on the stock and the lease. The trust name is on the stock and lease, and there's language in our agreement, there's language that says that when the grantor passes away, that the beneficiary passes away, that whoever they want to transfer to has to go through the full application process. So even though they're the residuary beneficiary, they still have to go through the whole process and get the approval of the board.
right, and that's not necessarily will to pay. I'm just bringing up the point because you
Right.
have to specify that.
Yes, yes. She's had her hand up and.
I have two questions, actually. I agree with the woman over there, we don't permit trusts in our co-op. But here's a question, if we were thinking about allowing it, but this just changed my mind, we'll go back to the board, I don't think we'll want to do it. Let's say that you check all the wording and you do everything for us and we agree to it. And the person, the shareholder passes away, and her niece or daughter or will not leave the apartment.
Well, you have to bring an action.
Again, that's gonna cost the co-op more money.
Well, it should
But you'd
cost
have to
them the
bring
money.
action anyway.
Cost them the money.
That doesn't change, that particular issue doesn't really change by virtue of the fact that it's a trust. You could have an apartment where the shareholder's living there, and their niece is living with them, and they pass away, and the niece won't move out. It's not really affected.
Or they move in.
Or they move
Well, we
in.
don't have a lease move in, you know.
Well, they just move in.
Either way, say they're living there with their aunt, right? And the aunt passes away, and the shares are in the aunt's name, not in a trust. You still have to get the niece out. You still have somebody that's living there. That's totally separate from whether the stock is in the trust or the stock is in the individual. You still have somebody at the end of the day living there who's not the person or entity that's on the stock.
And I also noticed for underlying mortgages, they ask whether any rentals, we're 100% owner occupied. Then we have to answer questions on the trust, how many trusts?
Yeah, well, I haven't seen it. They ask for a trust, I haven't seen that one.
No, on the questionnaire. Now, my other question is totally different. Let's say we don't permit them, which we don't, so a lot of our elderly shareholders have wills. The amount of time, I want to know, what's the difference between the will going through probate or having a trust?
Okay.
Before they
Trust
have to-
doesn't go through probate. Trust has
So
been,
how long does it take for the trust?
The trust is nothing, the trust is the application process. The trust is just when the person passes away, unless there's some kind of dispute between beneficiaries, whatever, but assuming that's not the case, you just go through the application process, the person puts in an application, it's the normal application and transfer process. That's in a trust.
Okay.
If there's no trust and the person has a will, okay, so now whoever the executor is of the will or the beneficiary, somebody has to probate the will, right? And they have to go through circuit court. It's at least a few months, at least. It could be, I mean, it's hard to say. It depends on how many, I mean, Joe can speak to this. It depends on how many.
depends whether Joe is there or not.
It depends on how complicated an estate is. It depends on how many years, how many,
Up through 2015, it was anywhere from probably 3 to 4 weeks.
That's once they got the file though,
Yeah.
and everything.
And again,
It was ultra smooth.
Right, this assumes no contest, this assumes that your papers were accepted. This assumes,
Well, if it's,
There's, as he's saying, there's a lot of assumptions built in. Paperwork's perfect, it's accepted, nobody's fighting it, everybody signed waivers, so you don't have to do a citation. You know, if you don't have that, or if you don't have a will, and if you didn't have a trust and you didn't have a will, then the process is much longer. You know, then,
Okay, I'm sorry. So I don't know what this question is with either or both of you. Is there a scenario where a trust is created or any other, maybe for a will or something else, where the government comes in? Where the government, for any sort of Medicaid, Medicare, anything, where the government comes in and can take the asset? Because that was something that came up once. It never happened, but it was a conversation that was had.
the fundamental idea behind most of the trusts that you're talking about is to prevent exactly that from happening. Okay, now if it's done right, then it's going to be a non-issue. If it's not done right, you're going to have an issue. I know that's a very broad answer to your question.
I understand.
But
So
the
basically,
fundamental,
the building's attorney.
yeah, the fundamental premise is if you're doing the planning and you've done it correctly, the government is not going to be an issue.
well, the issue for the co-op, see, that's a lot of the language that I see, they structure it so that in fact the government can't reach this asset because it's in the trust and that's it. And they have language that, and it's been there for the right number of years, so there's no look back and all of that.
And that's why most of these trusts tend to be irrevocable.
Right, but that language also, the way they write it, tends to apply to the co-op's ability to reach the assets. And that's why I have to tell them they have to make an exception in the language.
Can I just make a comment? The reason that you would want a trust in your co-op is that all of the assets of the trust are available to you on the death of the grantor. So then, if I die, all of my assets can pay the monthly maintenance, can pay blah, 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 whatever. So that's one reason. It makes it easy to continue into business until the apartment or the property can be sold.
But we have a lot of people that have wills and they're still paying, after the person.
They have a will, that's very different.
Well, that's not good. I think, I haven't seen it, I guess it's possible. I don't think the issues are so much where if somebody dies that the co-op's not getting its maintenance, or that they won't get it when it's sold, because that's when it's sold, it's going to come out of the proceeds. I think it's during the course, it's protected as they go
So
on.
for us, it's more of who's going to be living in the apartment after.
Well, living in the apartment has to get taken care of in the trust, and it's almost easier in the trust because they've all agreed to it ahead of time. It's...
Doesn't always mean they do.
No, but if they don't have the agreement, they can do what they want.
you're gonna have that problem anyway.
You have to go
You're
back.
gonna have,
That's right.
if you don't go after them, you can end up in a situation with whether there's a trust, whether there's a will, whether there's nothing. You can always end up in a situation where somebody's, niece, cousin, brother, child, roommate. Everybody has a right to a roommate. I mean, so that whoever it is living in the apartment, and the shareholder, and the shareholder passes away. Now what? That person isn't just going to leave the apartment. They might stay there anyway. And that's the situation you're talking about. But that can happen no matter what vehicle you have in place or no vehicle. You can still have that issue.
And if that person does stay there, don't go to the Westchester Surrogates Court to get them out. Right. Go to your local court.
In addition to that, it happens without any of this. It happens with the sublets. You put somebody in, they're supposed to leave, they don't leave. You can always have a problem. You all know. You get to a certain age and you know there can always be a problem.
Would there be a problem with, maybe it's an immediacy of what happens when the person dies, and say the recipients of the trust want to come in, and they want to live there, they want to come in and they want to renovate completely the whole apartment.
Well, they would have to go through the same procedures as anybody else.
But they would be able to do that in the time frame it takes, because they're not living there.
There could be, when somebody passes away, you need somebody, whoever, if somebody wants to go in, they have to have some right to do so. So they have to be the legal representative of the estate, whether it was by the person who had a will and they probated the will, or they didn't have anything and they did an administration. They have to actually do something. It's not enough just to have the will. You have to go to surrogate's court and probate it, which means you present it to surrogate's court with the right paperwork, you notify all the people who are interested parties to the will, you let them know that it's there and you're offering it, and then the executor gets appointed and actually goes through that process. But somebody has to have that right. You can't just say, because I'm the child and I'm on the paperwork or something, I'm going to go in and do it. You have to get the permission.
Okay, but here's the question. The trust gives, actually transfers the ownership of the shares to somebody else.
No, to the trust.
No, yes, it transfers into the trust.
Okay.
So if it is the John Doe, lifetime trust, then that's the name that's now going to be on the stock certificate. The stock certificate is going to say the John Doe Lifetime Trust. And the lease is going to say the John Doe Lifetime Trust. That's going to be the name that's on the document. And the part of our agreement is who can live there. John Doe, the beneficiary of the trust.
So the trust doesn't go to the beneficiary.
Well,
The shares is not the beneficiary. That's the question.
well, the beneficiary is not necessarily the trustee. Trustee administers. Often, somebody says, I want my nephew and my daughter to be co-trustees, right? But the beneficiary of the assets are going to be my two sons and my daughter equally or something. What that means is that they're allowed to get the proceeds, but nobody has a right to do anything without the card.
So it always remains in the name of the trust.
Yeah.
Until the transfer agent transfers it.
Right. So that's what it is. And interestingly, I don't
They have to go
just
through the
say
application process.
when they
That's why
die. This is a big negotiating thing. I say if they're not living there, sometimes I say 8 months if they push me, I like 6 months. If it looks like the person is not returning, I want it to be, that it has to be sold essentially, because nobody else can live there. And that pushes people to do the right thing.
You don't know what assets might be outside of the trust, so potentially there could be beneficiaries by operation of law, there
Right.
could be an estate.
Absolutely.
Do you have a right to ask for a personal guarantee from those outside of the trust?
I do. I get the guarantee from the grantor and the trustees. I mean, I can't start from the,
Do you ask for any of the beneficiaries, so for example?
they're not going to do beneficiaries, because the beneficiaries don't have anything until, yeah, I mean, there's a limit to what, how far people tie up their things. But to the extent that they're involved, I think they should be.
And you still have the asset too.
Yeah.
So.
It's just that that's an illiquid asset.
Well, that's something.
It's an illiquid asset.
We want maintenance.
Yeah, but it's the same, I mean, you have the same issue, forget about a trust situation, forget about a estate situation. If you have a shareholder that's not paying their maintenance, it's the same thing. You have to go to landlord-tenant court, which, as we all know, is now harder. And you have to, and then ultimately you would foreclose on the asset and then sell it. The difference here is it's in a different name. And I mean, if you take one thing away from tonight, it's that it is important for everybody to do something. And having, a will that names somebody that's going to take care of it, make sure that's updated, that's, even if your co-op doesn't want to do trust, fine, make sure everybody has a will. The worst thing is when there's nothing, and then there's nobody to take the asset, and then you have to go through, and then it's just so many different layers, because you have to go to surrogate's court for an administration, and if there's no family member or anybody to take care of it, you have to get the public administrator appointed so that we can foreclose. So we still have to go through the landlord-tenant process in the local court, but we have to get the public administrator appointed first so that we can get somebody to serve for the landlord-tenant proceeding. And getting that, you have to get the death certificate, you have to do an air search, you have to do the petition, you have to, you have to serve everybody. I mean, that is months and could be years. I mean, it's a process that's extremely long, that can be long, and for no particular, for no great reason. But it's something that is infinitely shorter if everybody has at least minimal estate planning of a will with somebody that they trust that's going to, carry out their wishes.
Can a co-op request and require that?
No.
I don't think you require it, but you can certainly advise people and educate your shareholders that it's a great thing to do. But, yeah.
Suppose you have two people, living in a co-op. They're both on the certificate, both on the proprietary lease, and one person dies. Is the survivor obligated to, take the dead person off the lease?
No. It depends on, no, but it depends on how they're titled. If in New York State, there's a couple of different ways when, whether it's real property or anything that you own, there's a couple different ways that you can own it. One is called tenants in common, which means the two people have, or it can be more than two people, have completely separate interests. They both own that undivided portion, but it doesn't automatically go to the other one when one passes away. So what would happen in that situation if two people own, the property and they own it that way, then one person passes away, you would still have to probate or do some kind of probate or administration to get the right to then transfer that person's portion out of them. And it would go to whoever's on their will or whoever their next of kin is. If you own it the next two ways are kind of the same thing, but either joint tenants with right of survivorship, or if it's a married couple, it's called tenants by the entirety. Either of those two ways, then when one person passes away, it automatically goes to the other person just by operation of law. So in that instance, even if you have husband and wife on the stock as husband and wife, you don't have to do anything. If one of them passes away and the husband passes away, the wife wants to sell the apartment, all she has to do is have a death certificate. And then that's enough to show that, if the stock certificate is phrased the right way, she has the stock certificate and the death certificate, and then she can transfer it.
I'm talking about the board, not necessarily to sell it. I'm talking about they're obligated to the board to change the certificate to this owner.
No. If they have, it's the same thing. If they own it that way, then it would just pass by operation. They don't have to change the stock certificate.
We have time for one more question. Going once? Going twice? There you go.
You were talking about the procedures you go through when somebody wants to transfer a unit into a trust.
Yes.
Particularly when the trust is already there. Would there be anything different if somebody's already got the trust and they want to buy the unit? You just go through the same review process.
Trust wants to buy.
They want to buy the unit in the trust.
They have a trust set up, and the trust wants to buy.
Oh, the trust wants to buy. You mean that's a more complicated issue because then you have the issue of who's going to live there. Okay, so that would have to be either negotiated, or the board would have to say they're not going to allow it.
In the other situation, you already know who's living there because they're there. In this situation,
So,
you gotta make sure.
and you wouldn't necessarily want a beneficiary to be the one to live there unless you approve that beneficiary. So that could get a little dicey.
Generally, same procedure though.
Yes, it's the same procedure, but it could be more difficult because it's not who's living there and